Hello and good evening, everyone. Welcome to tonight's webinar on special needs trusts. Without further ado, I would like to introduce our panelists. Our first panelist this evening is Bhavik Patel with Sandberg Phoenix. The second panelist we have this evening is Casey Stevens with Midwest Special Needs Trust. And we have Michael Chiodini, who owns his own financial business, and he will talk more about that later. So at this point, I'd like to go ahead and turn it over to Bhavik to start us off.
Thanks, Anne, as always. Hi, I'm Bhavik Patel. I also have my partner, Josh Hutkins, listening in today, and he might chime in, so you may hear from him. But today's sort of workshop is about special needs trusts, how they are set up, what kinds they exist, what can they do, who can oversee it, and all of these great things about special needs trusts will come out today. But before we jump into just special needs trust, I think it's really important to sort of make sure everybody understands the why. Why are special needs trusts needed? And the answer to that, just very briefly, is so that we can optimize and we can be eligible for certain public benefits that might be available for our loved one with a disability. Now, I'm going to set the framework a little bit and talk a little bit about public benefits, the eligibility rules of those public benefits, talk about special needs trusts and the general types of special needs trusts. And then I'm going to pass it on to my esteemed panelists to give you some additional deeper perspectives on special needs trusts. With that said, I'm going to share my screen and kind of go through a presentation that I've put together. So just broadly speaking, one of the reasons we talk about public funds and public benefits and things that we want to preserve for our loved ones with disability is because it's out there, it's available to us, and we ought to think about using them for our loved one. You'll also hear of other methods of funding to take care of your loved one. We call those other methods private funding, whether that is what you, mom and dads and brothers and sisters and grandparents and whoever else is on the call, what you yourselves can do by leaving money in a safe vehicle for your loved one. That's what we call private funding. And we'll talk a little bit about that today too. So the importance of public funds. I mean, first of all, let's just kind of understand what they are. Public funds are benefits that are set aside by the federal government and ran by the state governments, and is used to care for people with special needs. So that should cover everyone that's on this call or on this video conference. Now, the funds specifically are usually meant to be used for particular purposes with particular rules for the individual with a disability. It's fully appropriate from our assessment that we all try to take full advantage of receiving public benefits as long as it does not disrupt the quality or the independence of your loved one. With a little planning, you will probably have a combination of some public funding and private funding that's going to be there for Joey. And I, by the way, loved one with disability, loved one with special needs. I'm just going to shorten that, but in my vocab, and others use other names, I'm just going to call that individual Joey, so that I don't keep saying loved one with a disability or loved one with a special needs. Now, there are two broad types of public benefits. There are those not based on financial need. We're not going to talk about those today, but those would be your good old-fashioned Social Security, also Social Security disability income, and then Medicare, and then other things like special education and things like that. But the other column, those public benefits that are based on financial need, those are referred to as supplemental security income, or SSI. And I'm sorry that all the letters are so similar. SSI, SSDI, it's probably the two most confused acronyms I've ever experienced because everybody uses them interchangeably, but they're not. They're very different. SSI is supplemental security income, and it is a financial need-based public benefit. Then you've got Medicaid as your other big financial need benefit. Again, we have other workshops. They put on other workshops that talk about these benefits in a lot more detail. Today is not about those benefits. It's just the concept that there are benefits. And in order to get those benefits, you have to establish financial need. And this will all come into play as to why special needs trusts are important shortly. For these public benefits that are financial need based, there are basically there's SSI and Medicaid, as I established. SSI is money that you receive from the government that would be for Joey's food and shelter and sort of like those core needs, but not for like vacation or fun or recreational needs. It is for food and shelter is the best way I would try to remember it. And then Medicaid is for healthcare, nursing care, in-home care, group home care, respite care, and all of these such important and valuable services that could be provided for Joey. In terms of being eligible for SSI and really Medicaid as well, there are essentially two tests that you have to think through in terms of becoming eligible. And this is about as important of a topic in this test. And the way I do a little bit of an analogy to it, I talk about it, you're standing in front of a door, and on the other side of the door is public benefits with financial need-based elements. And we want to unlock the door and we want to open the door so we can go to the other side for benefits. And so there are two tests that you really need to understand. And the first I call the resource test. Some people call it the asset test. It's got a lot of interchangeable words, but I call it the resource test. And it's the test, and this is very important, it's the test that unlocks the door. So remember, I said standing in front of a door, the other side is the benefits. In order to get through it, you have to at least unlock it first. So the resource test unlocks that door. I will talk about what that test is in a second, but I just want you to understand the concept as I apply it to this analogy. And then the income test kind of tells you how wide the door is going to be open. There's a door, other side of the door is public benefits. And I'm sorry I repeat things because I know how important this is. In order for you to unlock the door, you have to pass the resource test. In order for you to open the door and open it as wide as possible, depends on how well you do on the income test. So what are these tests in particular? The resource test. First thing I would ask you to answer is, well, the test is called a resource test. What is a resource? And the thing I want you to really start with is that every single thing is a resource. And in essence, anything that can be converted to cash is a resource. So even the shirt I'm wearing, if I sold it for a penny, the shirt I'm wearing is technically a resource. Or the money in a bank account is a resource. Or the home I live in is a resource. Or the car I drive is a resource. I want you to start thinking about everything. And if it's for Joey, this is for Joey for what it's worth. And if Joey is under the age of 18, then they're going to also look at mom and dad's resources. Regardless of whether mom and dad is divorced or not, they're going to look at both mom and dad's resources in order to see if the resource test is met for Joey. Now, if Joey's over the age of 18, they'll stop looking at mom and dad's resources and only look at Joey's. Now, what is the actual test? And They're a little different for SSI and Medicaid. For SSI, the resources that Joey must have shall not exceed $2,000 in essence on the first day of the calendar month in which he applies. So if today is November 15th and Joey applied for public benefit, in particular SSI, they will look at what Joey's resources were on November 1 of this year. And if they were more than $2,000, the door is locked. If they're less than $2,000, the door is unlocked. Well, the eligibility resource test is slightly changed or different for Medicaid. Here it's a little outdated in 2021. It's $5,035 for Medicaid for Joey. So I want you to leave this presentation not remembering both of those numbers, not caring about the higher $5,000 number, unless it's really uniquely relevant. But I want you to think of the $2,000 number. I've always said, remember the lowest number, because that's going to give you the biggest amount of safety for all the public benefits available. So even though I'm technically not correct when I say it's a $2,000 resource test for SSI and Medicaid, that's what I want you to take away, and I want you to remember. You must pass the resource test to unlock the door to benefits. Now, I told you what resources are, and I told you everything is a resource. At least that's what I wanted you to start off with. Now I'm going to backpedal a little bit, and I'm going to specifically exclude out certain assets that are not part of the resource test. One is a home that is owned by Joey and in which Joey actually resides in. Then the value of the house is not part of the resource test. And just again, I know I'm being repetitive, but remember, have to pass the resource test in order to unlock the door. And here we're getting really close to understanding why special needs trusts are very, very important. Household goods that Joey owns that altogether are worth no more than $2,000 in market value. Here's the thing, I wouldn't put too much focus on household goods because no one really knows who owns the iPad, so to speak. So there's not a lot of attention given on the household goods area, but that is technically what the rule is. So I wanted to bring it up and let you know. Another exempt resource is a prepaid funeral. So it's a pretty morbid thought, but if you have some cash and that cash is disqualifying Joey from certain public benefits, well, you could go and prepay a funeral, and then that asset, the prepaid funeral, is an asset of Joey's. That would be an exempt asset, and it would no longer lock the door, so to speak. A few more exempt assets. One is a vehicle, one that doesn't have a current market value that exceeds $4,500. So I make a joke. It has to be a relatively unsafe vehicle because $4,500 in today's world for a used car doesn't take much to get there. However, if the vehicle is medically necessary to transport the individual, then the entire value of the vehicle is exempt. So that's where those handicap accessible vans come into play. Those things could be well over $100,000, and those would entirely be exempt. So keep in mind, I'm going through what's exempt, and that is a house, that is a car, that is a household goods, and a prepaid funeral, and a life insurance policy. That's the next one. with cash surrender value of less than 1,500. This is life insurance that Joey owns, okay? Not what mom and dad own, what Joey owns. An ABLE account, for those of you that know what those are, but as long as the value is less than 100,000, that's excluded. And then drum roll, I guess, the whole reason we're here, assets in a properly drafted special needs trust. Any amount of assets in the special needs trust, if done correctly, is going to be excluded from Joey's eligibility. In other words, the door is unlocked, even if Joey has $5 million sitting in a special needs trust for him. And so that is why it's important. So let's talk about the types of special needs trust. What I'm about to tell you is basically my way of categorizing special needs trust. You could try to Google it and you won't find it unless I wrote an article about it. So try not to Google what I'm about to say because it might cause further confusion. But there are two broad types of special needs trusts. And the categories that I identify them in is what I call reactive type of special needs trust and proactive type of special needs trust. Now, I use those words because I want to be sort of easy and intuitive for all of you to think, well, proactive is ideal. Being proactive is usually an advantage. There's usually a greater result in being proactive versus reactive is at least an option, but we're forced to consider what options because we're reacting to an issue. Now that you know what locks and unlocks the door, the resource test, the issue that I refer to that we're reacting on is whether Joey has violated the resource test. And if he has violated the resource test, we have locked that door, and now we need to react in order to hope for that door to come unlocked again for benefits. So the broadest category of reactive special needs trust has many names. Some people call it a D, like the letter D, number 4, letter A, D4A trust, or a first party special needs trust, or a self-settled special needs trust. I commonly refer to it as a Medicaid payback trust. And I use that terminology because it describes why it's not ideal. In its title itself, Medicaid Payback Trust suggests that the Medicaid has to get returned or paid back if there's any money in the trust. And so that's not ideal. So, but why it's a reactive category type of special needs trust and why it's called a self-settled or a first party special needs trust or a Medicaid payback trust all depends on whose money is going into it. So let's say mom and dad put $100,000 in a special needs trust for Joey. That is not a first party special needs trust. First party is through the lenses or through the perspective of Joey, the disabled individual. So if Joey has $100,000 in his hand or in his bank account, and that's causing the door to get locked, then Joey could react by taking that money and putting it in a Medicaid payback trust. And now all of a sudden the door becomes unlocked again. And Joey can receive those public benefits while still having this trust supplement his needs during his lifetime. The downside, because this is in the reactive category, not proactive category, is when Joey passes away, a lot of that money, if not all of that money that's left over, must go back to the state to reimburse them for any Medicaid expenses incurred on behalf of Joey. That is not the ideal scenario. It's an option if we have to deal with it. There's other reactive tools like the ABLE account and things like that, but we'll talk, I think more will come on that later. So now switching over to the other side, the proactive special needs trust, those are often referred to as third-party special needs trusts, meaning someone else's money other than Joey's is going into that trust for the benefit of Joey. Okay, and that does not have any Medicaid payback provisions. Now, there are two broad types in the proactive camp. They're often referred to as, and now I'm starting to string together a lot of Latin phrases, sorry, but testamentary third-party special needs trust or standalone third-party special needs trust. The difference between those two special needs trusts are, when do you want those trusts to sort of get born, to come to life, to start to function? Do you want it to come to life after mom and dad pass away? Or do you need it to come to life right away, even while mom or dad are alive? There's no right or wrong to this. It's just a matter of circumstance. A question I normally ask my clients is, well, do you anticipate, excuse me, do you anticipate anyone leaving Joey money during your lifetime, like an inheritance from grandpa or uncle or aunt or a sibling? And if so, you probably need a standalone third-party special needs trust. Now, all of these trusts that I've talked about, reactive or proactive, can be done in really two ways. Either through a lawyer, such as myself or Josh that's on the call here, where we will sit down with you and we will customize it and make it fit your particular needs, which isn't necessarily always what you need to do. You don't need sometimes extra customization or things like that. But that is one way to create any reactive or proactive special needs trust. But the other way you're going to learn today when Midwest Special Needs Trust talks to you today, but it is through sort of a quasi-governmental ability, and you would use sort of these master trusts that are already created, and then you can customize portions of it. And then I won't speak on behalf of Midwest Special Needs Trust on all the other unique applications it has, but I wanted to frame all of that so you understand sort of why unlocking the door is important, why special needs trust is a huge, huge tool for you to make sure you don't lock the door, and then the types of special needs trust and the methods on how you can create those special needs trusts.
Is there an age when it would be a person would be too young to set up a special needs trust? And also on the other end, is someone ever too old to set up a special needs trust for them?
Well, the younger part, there is no age. There's no, you are too young to have a special needs trust. So on that front, you can have it at the age of birth. Or you can have it at the age of, 20. On the upper end, depends on the type of special needs trust. But if you're doing a proactive approach and you're doing a third-party special needs trust, there's no age limit. You can set it for a 90-year-old if you want. But if you're doing a reactive special needs trust and they're over the age of 65, I believe, then you might have to get a court order to do it. Okay, so there's a methodology that would be required that might be overly involved if they're 65 or older. I'll just ask these questions, read them out loud and answer them. Is a special needs trust set up differently if you are the grandparent versus the parent? The answer is no. Grandparents can set them up, parents can set them up. Differently is yes, between every human to human, if you're wanting to customize it to what's important to that human, but not because of the generational difference. What tax strategies do you suggest for a special needs trust? What about investment strategy? First and foremost, the priority is public benefit eligibility. And Mike, I think you want to answer that question, so go ahead.
I do think that there's some tax strategies, and it depends a little bit on the type of trust and how it's structured. But from what I've noticed is that if there's retained earnings and dividends and interest inside the trust, they're taxed at the trust rate, which is a compressed tax rate. So you're taxed at a higher rate sooner on the income that's earned. And so while a lot of the times we see a lot of that income flow through to the child's tax return because it's being used on the needs of the child, if it's retained in the trust, we tend to favor municipal bonds, tax deferred annuity contracts, and just more favorable tax advantage strategies to keep that income down.
Yeah, great, Michael. That's right. You can minimize what the income taxes are by choosing what investment strategies you guys are following. But I would also say, big picture, the priority of special needs trust is not necessarily always to optimize income taxation. Not that we can't do it by creative planning, but the priority is to unlock the door. Is a special needs trust limited to intellectual and developmental disabilities? What about traumatic brain injury as an adult, injury on the job later in life that leaves you disabled? No, the answer is it's not limited to intellectual and developmental disabilities. It's in essence a tool for anybody that is trying to seek public benefits. And brain injury as an adult is certainly eligible for public benefits, just as an injury on a job later in life, or, honestly, major back pains that prevent you from being able to keep a job. And so you might need to be on certain benefits. So there's a variety. You still have to pass the eligibility test, the resource test. You still have to unlock the door. That's harder as an adult that gets injured, that's accumulated assets. But no, the special needs trust does not care, so to speak, of what the disability is or the cause. What happens to the home when Joey dies, since it is an exempt asset? Well, if Joey owns it and Joey dies, Medicaid can attach a lien to the house. And then when the house is sold, Medicaid would get reimbursed. It's just while Joey is alive, he can own the house, and it's not going to prevent access from Medicaid for him. However, proactive strategy would say you get that house and put it in a third-party special needs trust, and then it's exempt because it's in that special needs trust, not because it's a house, but because it's exempt. And even if Joey ends up going in a group home or a nursing home, that house is not going to exempt him from, it's not going to exclude him from public benefits. And then when Joey dies, the special needs trust itself is going to be drafted to say where those assets go upon Joey's passing, whether it's going to Joey's sibling or charities or whatever the case may be.
And then, Vivek, just to clarify on that, it would be the trust itself could purchase the house, and then the house, or the trust is the owner of the house, or mom and dad would have to transfer the house into the trust. But once Joey owns it, he can't then transfer that into the third-party trust, trying to avoid Medicaid that way.
Yeah, and remember, Joey can never take his assets and put it in a third party. If Joey owns the assets, you are not able to be proactive anymore. The proactive category is closed, and you would have to react, which means you would be dealing with him owning the house or putting it in a Medicaid payback trust, which would have the same result. Can a trust pay for a cell phone, data plans, internet? Can they buy birthday, Christmas gifts for family with trust funds? What about when you are on a family plan like for a cell? The answer is yes, it can pay for Joey's expenses in essence. Okay, I'm gonna oversimplify that by not getting into too much detail, as some of those things are going to come up later. But the special needs trust does in essence have to be used for the exclusive benefit of Joey. So Joey's special needs trust can't pay for my dinner. I mean, I'm just kind of making up something silly. So just to be aware of that. But some nominal gifts can be probably authorized, but I'd be very careful with that. It's an argument that the state could have that you didn't use it for the exclusive benefit of Joey. Do you need to review as the law changes? Do laws change frequently? I'd say a good 3 to 5 year rule applies. Every 3 to 5 years, have your trust evaluated, have your entire estate plan evaluated. I think those would be, that'd be a good thing to practice. It doesn't necessarily, these concepts don't really change, but nuanced details of it could change. And we have had special needs trusts that were appropriate when we drafted them. And several years later, the states decided to focus on something particular that caused a lot of our special needs trust to be tweaked, that needed to be tweaked. And so constant review, and constant, I don't mean excessive, every 3 to 5 years is good. Okay, so a couple of things just to be aware of. Transfers to Minors Act accounts or 529 plans, or most accounts as you might know them as, or uniform transfer to Minors Act accounts or custodial accounts. All of those types of assets are resources for Joey. So just think about that real quick. If your plan is to have Joey maybe remain eligible for public benefits, you may have to do things differently than a typical developing child that's not going to need public benefits. You may shut that door or lock that door by having transfer to Minors Act account or a 529 plan. And I'll let Mike speak on that a little bit more when he gets to him talking. So just 4 more other things I want to point out. Unstructured beneficiary designations is something that happens a lot. Either you don't name beneficiaries on your IRAs, 401ks, life insurance, and when you pass away, that's going to become a problem because then Joey's going to be entitled to an inheritance. And if Joey's entitled to an inheritance, that's going to lock the door. Now you're reacting when little proactive planning would have secured all of that money for Joey's care and needs while you still got public benefits. But the other thing about unstructured beneficiary designations is I presume most of you work. And if you have a job, if you could go way back to day one of your job and you filled out all this paperwork and did orientation and you filled out, your W-2 and you filled out, well, I'm going to sign up for the life insurance that my employer offers me, or I'm going to sign up for the 401k. And then they ask for beneficiary designations. And then you probably name your spouse as the primary beneficiary. And then what do you do for the secondary beneficiary? You name your children. And I can guarantee you, some of you listening is nodding your head up and down right now, saying, yeah, that is what I did. Well, if one of your children happens to be Joey, that's a problem, an inevitable problem, depending on the order of death, that's going to cause Joey to be disqualified from public benefits. Instead of naming Joey, the solution is you name the special needs trust for Joey. And then your problem solved. You're good. That's simple of a solution to solve probably one of the most common things I see that disqualify people from public benefits. The third one that's on this screen talks about giving money or inheritance to another family member to hold for Joey, which is all great if it works out. No one can guarantee it. But even if you could pretend to guarantee it, if you left it all to Emily, Joey's sister, and then what happens if Emily dies? Well, if Emily didn't do some proactive things, that could go to her surviving spouse or her kids instead of Joey. Or worse, what happens if Emily's married and divorced? Now that stuff that you left for for Joey in Emily's possession, now might go to Emily's wicked ex-husband. Or what if they had liability issues or got in a car accident? I mean, there's so many things that could go wrong by leaving money to Emily to take care of Joey. The solution is so much easier. You'll leave it in a special needs trust for Joey. You could name Emily in charge of it if you want, or you can name someone like Midwest Special Needs Trust to be in charge of it if you want. And now if any of those things happen to Emily, that money is still secure for Joey, with Emily still having a big say in what's going on. That's so much safer than betting. Why are you gambling on Joey? That's a hot topic of mine. I really hope you don't disinherit your disabled child, because nothing about that sounds right, in my opinion. And then gifts from other people. We talked briefly about that. Grandpa, grandma, leaving money for Joey. If you don't set up a proper special needs trust to receive that gift, it could lock the door. And then lastly, if you yourselves don't have a proper estate plan, then when you die, the state in which you reside has written an estate plan for you, and it might very well leave some money upon your death to Joey. And if that happens, you've again locked the door. So you cannot rely on doing nothing. You're going to have to do something. I'm sorry to be that bearer of news, but it is very important that something be done. Now with that, I'm going to go back to the Q&A. You may already have touched on this, but if a decedent estate distributing money to a person with a disability, but has not cut the check to the person, is there a way to be proactive or send the money directly to the trust instead of the person prevents the benefit doors from locking? Great question. And I cannot answer it without specifically looking at the documents that left Joey the money particularly. So all I can tell you, the best I can answer is there is a chance to be proactive, but you're going to need to act fast. But there is potentially an opportunity. It just depends on how much flexibility was drafted in the documents from the original people that drafted the documents. Can Joey have both a reactive and a proactive? Yes, absolutely. In fact, Joey has 100,000 in his pocket. We have to be reactive. That doesn't mean we can't still leave your inheritance to Joey in a third-party special needs trust. For tax purposes, what are my contributions to my child's special needs trust considered since they are an adult? Are they a donation, or do I need to report annual contributions on my taxes? Well, first of all, there's not an income tax consequence to it. So then the question really becomes, if my child is an adult and I leave them money, do I have a gift tax issue? Well, first of all, there's an annual exclusion, $17,000 next year, $17,000 a year per person. If there's you and if there's mom and dad, that's $34,000 a year that you could put in there without any gift tax exemption usage. But then you also have your what's called your applicable exclusion amount or your lifetime exclusion, which is getting into tax heavy, but that's, basically $12 million of total that you can give away either during your lifetime or at your death. So you wouldn't probably pay gift taxes. That's probably the best way I could answer that at this level. I want to buy a condo or a house for my adult child. What is the best way to own it to preserve his benefits? Third-party special needs trust owns it, or you own it in your name. And when you pass away, you leave it in a third-party special needs trust for Joey. Either one of those would work. Can you use funds from a special needs trust secure an I bond? Yes, a special needs trust can own an I bond. I believe Michael might know better.
You are correct.
Okay. So that, and then we talked a lot about some income tax strategies, how you invest your money and making them not be income producing is a way to minimize your income. Just the growth, in other words. Recommendations related to a special needs trust for parents with a child on the milder end of autism. So this is what I call, sorry, go
I
ahead.
can actually expound on that a little bit because I
Okay.
believe I talked with this person earlier, and they are not sure their child is a grade schooler. And the reason the mild piece comes in is, what if this child grows up and becomes independent and can
Yep.
live on their own and doesn't
That's what I
need-
thought the question was. Absolutely. So that I call that the gray zone. And there, and mind you, we don't talk about everything, but there is a type of special needs trust. This would be more on the customized side. I don't know if Midwest Special Needs Trust would have this option or not. There is something called a spigot special needs trust, just like it sounds, turning it on and off like a spigot of water. And it is a very commonly used, useful strategy we implement for families that are in what I call the gray zone, where we don't know how independent of a life the child's going to have, whether they're going to have full-time earning capabilities, and whether or not they're going to ever even need public benefits. And so we create the flexibility. It's basically a regular trust that has the capability of becoming a special needs trust if public benefits are at play, or turned off if there's no chance for public benefits. And that can be decided as life evolves and as dynamic as life continues to evolve. Casey, do you guys do that? Those spigots or no?
No, not
Yeah,
something
okay.
we can do. We have provisions in our master trust to close the trust if no longer considered disabled, but other ways around that without specifically calling it that.
Got it. Yeah. And if you close it out, it just goes to the beneficiary.
First party does, third party goes to a standby trustee who would administer.
Got it. Got it. A standalone trust can be an empty trust that is not filled until inheritance. That is absolutely true. Also, can people leave the trust as a beneficiary? Yes, they can. if you don't need that empty vessel until mom and dad die, then the only reason for that testamentary option is because it'll save you some money. You won't have to pay as much in legal expenses. So you just have to be real about how likely is it that someone's going to leave Joey money. And if not likely, then don't spend extra money if you don't need to.